I'd like to welcome everyone to the Constitution Day event here at Grand Rapids Community College for 2010. I'm the President of Student Congress here. My name is Nicholas Wykar, and I'll be moderating the discussion today. Before you, the way it's going to work a little bit is for the first hour, we're going to be going through, we have a few questions just to get the conversation rolling off the bat, and we'll be asking them of our panelists here. I'm going to go over a few brief bios for them. And then we'll actually be able to, after they're done answering those few prepared questions, we'll be able to open up to additional questions you may have. After the first hour, we're going to go into a second hour, which will then be a more discussion-based session, which will actually be around specifically individual personal rights and ways of dealing with police officers if you ever encounter them, things of that nature. So are there any questions before we begin? Yeah, and Eric here, the Director of Student Life, Eric Mullen, he will be actually passing out cards. So if you have any questions at any time, just fill those out. You can raise them, he can come by and collect them, and we'll just go from there. And as always, feel free to help yourself to refreshments at any time. The restrooms are actually outside and around the corner if you need them. But again, I'd like to welcome everyone, and I'm going to begin with the bios. So the first panelist I'd like to introduce is Professor Yun Bai. Yun Bai was born in Beijing, China, and he came to the United States in 1987. He received his master's in public administration from Seton Hall University in 1989 and his PhD from Texas Tech University in 1995. At GRCC, Yun Bai teaches American government, comparative politics, international relations, and Asian politics. Thank you so much for joining us on the panel today. The next panelist I'd like to introduce is Heather Forrest. Heather's area of interest is in judicial politics and the impact of the Supreme Court decisions on the powers of other branches in the government. She has taught at GRCC since 2004. Prior to GRCC, she was at Grand Valley State University for a couple of years, and prior to that, Kalamazoo Valley Community College, excuse me. She teaches American government, and for those interested in constitutional matters, she is very excited that GRCC will be offering a new course this next semester called American Constitutional Foundations. So if any of you are interested in that after this session, please take part in that class. She would much appreciate it, I'm sure. So thank you so much, Heather, for joining us today. The next panelist I'd like to introduce is Professor Keith Sinclair. Keith Sinclair is a tenured political science professor here at GRCC and has been teaching political science since 2008. He teaches government and international relations. He holds 2 degrees from Illinois State University, a Master's of Arts in Political Science, and a Bachelor of Arts in Sociology. While in graduate school, he interned in London working as a research assistant for a member of British Parliament, which is pretty exciting stuff. And he currently lives in West Michigan. He's been living here since 1997 with his wife, Alice. Mr. Sinclair serves on the board of Michigan Conference of Political Scientists. He also remains an active member in the World Affairs Council of West Michigan and has been a guest lecturer for the National Issues Forum at Dirksen Congressional Center. So thank you so much for joining us today. All right, I hope to get the name right. I tried ahead of time, but our next panelist that I'd like to introduce you to is Gordon Verzik.
All right. Yeah.
All right, we'll try it. He is an assistant professor in political science at GRCC. Before coming to teach for us, he was an instructor of political science at DePauw University and Indiana University, Purdue in Indianapolis. He has a master's degree in political philosophy from Bowling Green State University, a master's in politics from the University of Amsterdam, Netherlands, and a master's in international relations as well as European studies from the Central European University in Budapest, Hungary. So thank you so much for joining our panel today. And finally, I'd like to introduce you to Pete Walsh. Originally from New Jersey, Pete Walsh has moved to Michigan and graduated from GR Catholic Central. He went to GRJC and obtained degrees from Michigan State University and Wayne State University Law School. He originally went to work for a small local law firm, but left and formed his own private practice in 1981 and has been in the law partnership since then. His concentration for practice is litigation in state and federal courts, including but not limited to commercial litigation, personal injury, divorce, and criminal law. The criminal law practice has included the defense of countless college students charged with a behavior that has either completely legally or tolerated when he was in college. It was the frustration of dealing with these students that in part led the republication of the book that Mr. Walsh has made available to you today. He joined the ACLU right after September 11, 2001, and joined the Lawyers Committee a couple of years thereafter. So thank you so much for joining our panel today, Mr. Walsh. All right, so to begin, we're just gonna begin with our prepared questions. The first question that we had was, what were the main ideas and focuses that the Constitution was built upon? And just how this will go is just anyone who'd like to start may start, and then we just ask you to refrain to just a few minutes because we only have an hour for the first panel. If we go over a little bit, that's okay. So would you like me to repeat the question, anyone?
No, the focus is that the Constitution was built upon?
Correct.
Correct, okay. Well, I guess it would depend on whether or not you're referring to the Federalists or the Anti-Federalists, but we'll go ahead with the general consensus was that the Articles of Confederation were not working, and the Constitution was based on preserving the individual liberty of the colonists, as well as building a central government that would function to avoid tyrannical power and disperse power, and recognize the rights of individuals and represent them in a way that was unprecedented at the time.
I think we also have to recognize the philosophical sources of the Constitution. One of my favorite philosophers, John Locke, who wrote this famous book, two treatises on government, and nobody really reads the first treatise. But in the second treatise, he basically established for the first time the idea that the government has to be accountable to the people. I mean, Locke sees a relatively narrow role of the government. He sees that the main role of the government should be to protect people's property, and basically as such, the only stakeholders in governing are people who own property. He even says, well, if somebody takes away property from you, that means that person enslaves you. So it's not only about material possession, but property is also the part of the human identity. And because government is supposed to protect property, that means, for Locke at least, that it has to be accountable to the people, and that particular idea is pervasive through the whole Constitution. I think we can also go as far as Magna Carta, which was the peace treaty that ended the 40-year war in England between landed nobility and royal family. And the document Magna Carta was signed in 1215. I think for the first time, Magna Carta creates this idea of classical political liberalism in which all people should be equal towards the law. Of course, Magna Carta didn't stipulate that all people in England should be equal before the law. It was only referring to landed nobility and royalty. But this was the beginning of thinking about how basically to create equality of the people before the law, and that's also enshrined in the Constitution. And then Montesquieu, big French philosopher in the 18th century, he was talking about the necessity of the creation of trust between large and small states. And when we look at the structure of the Constitution, especially the first part of the Constitution, first 3 articles of the Constitution that talk about different branches of government, we see that that these ideas of Montesquieu are also enshrined there.
Okay, talking about John Locke. John Locke talked about the importance of property, but ownership of the property is not the end. The ownership of the property is just the means to the end. To John Locke, you own some property in your name, I mean, you will become more responsible. And also, you own something, I mean, you don't need to worry about, daily life. So you got more liberty, you got more time to be engaged, to participate in politics. Also, Magna Carta was, that's passed in 1215 to limit the power of the king of the England. So the Constitution pretty much set up the government, but it also limits the powers of the government. Our government is not as democratic as what we tend to think of a government is pretty much set up as the Republican. So the Constitution, the purpose of the Constitution is to make the Republican government to be workable. And of course, for so many years, it has worked.
Just to pick up where Heather had touched on, I agree that the focus was really the failure of the Articles of Confederation, our previous Constitution, and what to replace it with. You had, under the Articles of Confederation, we were a confederation, 13 independent states, each with sovereignty to themselves. And that is sovereignty meaning the ability to have the final say over what transpires within their political borders. And there was no national sovereignty under the Articles of Confederation. It was just the states themselves who had the sovereignty, and yet that was a failure. They didn't want to go back at the same time to what they had under the British, where all of the sovereignty resided at the national level. So, thus the conundrum. They decided, in the genius really of this new Constitution, was to create a federal system of government, a federation, a new word to describe a brand new concept that Americans can take pride in that they invented, and a form of government that's been copied around the world. And that is a form of government where sovereignty not only resides at the state level, the regional level, but also at the national level. The national government is sovereign, and the states are sovereign just over different issues. And really the problem after that was resolving who's sovereign over what. And we've been figuring that out for 200 plus years, and the answers keep changing.
In the preamble to the Constitution, they pretty much established what they had in mind, form a more perfect union, since the union they'd formed under the Articles of Confederation hadn't worked, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, something that's frequently ignored now as a goal of our government, and secure the blessings of liberty to ourselves and our posterity. Those were the rationale that they sat down and wrote down, and I think you have to think that they meant it when they said that. They reached certain compromises. They struggled, as I recall, a lot with how do we make sure New York doesn't dominate Georgia at the time, which New York had a greater population, and they came up with the separate houses of Congress, one established where each state had 2 reps and the other based on population. I think there's a name for that compromise. I can't remember what that name was. They set up the separation of powers. They didn't want a king. You know, they fought a war for something, and they didn't want to go back to a king. So they established the separation of powers so that there were different sections of the government that had different powers. And most importantly, from my perspective, being from the ACLU, they fought a war, like I said, for a reason. They didn't like the British troops being quartered in their homes. They didn't like the British system of justice. So James Madison, if I'm not mistaken, proposed the Bill of Rights, and they passed the first 10 amendments, what we now know as the Bill of Rights, to establish personal liberties to protect you, the individual, primarily, from the federal government. And that might be in the long run, and from my opinion, might be the most important thing they did, and they have not been changed over the last 200 plus years.
Thank you. Does anyone have anything additional to add on that question that they may have missed? All right. So considering those ideas and focuses, do you believe that the framers of the Constitution intended for the Constitution itself to be a living document or a temporary solution at the time?
Well, I clearly, in my opinion, it was meant to be a living document. I think that horse was out of the barn quite some time ago. They keep bringing it up in certain circles about it not being a living document. I think the United States Supreme Court has firmly established that they're the interpreter of the Constitution. There's numerous examples where they've interpreted it one way in one decade and another way in another decade. It's the same document. The document hasn't changed, but the interpretation changed with the times. I think they meant for it to be a document that if you want to amend it, it's going to be real tough to amend it. You got to have what? I think 2/3 of the Senate and the House, if I'm not mistaken, and 2/3. Pardon?
3/4.
3/4. Even worse than I remembered, to amend it. They didn't want it to be changed, but they set it up so that we had the Supreme Court there to interpret it. And, you know, we've gone from, I don't even know if it's horse and buggy, if you want to call it, to the jet age. We've gone to computers. It's changed dramatically.
I guess I would say that there are some people that might disagree with it being a living and breathing document, because I believe Justice Scalia on the United States Supreme Court would emphatically disagree with that the document was not intended to be living and breathing, that the document was intended by the framers to be a document limiting the scope of the federal government, in which they listed the powers exclusively for the federal government and intended everything that wasn't listed should have been left to the states. And unfortunately, that's, for those people that believe that it is an absolute document, that's not the way that it developed, because of the makeup of the bench and who was on the bench at the certain time that a particular case came to light. But to say that the framers solely left the Constitution to be decided by the court, yes, I guess technically is accurate, but Alexander Hamilton himself said that the Supreme Court was the least dangerous branch and only devoted 3 sections of the Constitution to it, wherein they devoted, 10 to the legislature and 5 to the executive. So to say that they fully intended the court to have the kind of impact that they have today, I think is just misleading, personally.
I think Scalia is crazy.
I think he's awesome.
He's the man. I mean, he claims to be an originalist. That is, to interpret the Constitution as it was originally intended and written by the founders, which to me is crazy, because you know, all of these people at that time believed in the legalization of slavery, and
I don't believe all of them believed that.
Well, they certainly, it was legal under the Constitution that they wrote.
But it doesn't necessarily mean that they all.
Are you going to deny that they didn't see whites as superior to blacks?
I'm not denying it. I'm just
saying. Okay, well, what I'm telling you is that was
absolutely
their original intent. And these people wrote the Constitution. And if you're going to interpret it solely as they saw the world, then how can we have modern civil rights as we understand it? So I reject the whole originalist concept. I just think it's ludicrous.
Well, it's an argument of convenience that they use to avoid, it's an argument of convenience, just like stare decisis, that they use to justify taking a position. Quite frankly, sometimes to the point of intellectual dishonesty. They want to stick to some tradition that's become absolutely obsolete. And so they bring up stare decisis, this originalist argument. But then when they want to change something, we got no hesitation to change it because it's wrong. You know, they have no problem with that.
But both sides do that.
Well, but one side's honest about it and the other's not.
Let me say a few words on that. I'm kind of between judicial activism and judicial restraint. I'm not an originalist. I'm not a liberal.
You might want to clarify what those are.
But I think, I mean, you know, the original intent of Constitution, I mean, today, who knows? I mean, 200 years ago, you know, right, the original intent or the purpose of the founding fathers is very hard to find, to know. And also the stare decisis, also, you know, does Supreme Court stick with this principle all the time or sometimes? I mean, the Constitution is a living document. It's not like, you know, we don't change that by just amending that. I mean, it's living document. It's interpreted by the Supreme Court all the time. So that's a living document. I mean, the word in the Constitution, like, you know, treason, that's, you know, gave the enemy aid and comfort. You know, what's comfort? You gave the enemy some milk, some cookies, you know, you are helping the enemies, you are, you know, right? So the words are the same, but the meaning of the words have been interpreted or reinterpreted by the Supreme Court. So that makes the Constitution a living document.
Yeah, I frankly do not see the importance of the debate about what it is that founding fathers thought or what it is that they intended the Constitution to be. I think for us in the 21st century, what is important is whether we can still use this constitution to decide some important issues, whether these issues are about function and structure of the government, right? You probably know that several states, Michigan included, sued the federal government because it passed the new law on the healthcare, so-called Obamacare, because they're saying that there is nowhere in the Constitution where it says that the federal government has the power to mandate people to have health insurance. But what is important, I think, for us is to be able to ask ourselves whether we are capable of using and interpreting Constitution about deciding both of our rights and structure and function of the government. For example, if you think about the right to privacy, if I ask you whether you think that you have rights to privacy, I think most of you would say yes. And if I ask you whether you think that this is a constitutional right, I think most of you would say yes too. But the word privacy is never mentioned in the Constitution. There is no word which says privacy. So the right to privacy in the Constitution has been interpreted or extrapolated from different parts of the Constitution by a liberal court, right? But and I think that the interpretation as such is necessary. I'm a foreigner, so when I read American Constitution, that's the most poetic document in politics that I ever read, because it opens itself to interpretation. Right? If you look at the right to privacy, and then where is the privacy in Constitution coming from, right? It's coming from the word liberty, right? That it says the government should create no laws that would take away liberty, life and property without the due process of law, right? So the Supreme Court interpreted the word liberty as having, well, you have liberty to do whatever you like, especially in the case of abortion with your body, right? It comes from the Ninth Amendment, right? Which says basically if there are rights that are not specifically mentioned in this Constitution, that doesn't mean that humans do not have some other rights, right? So Supreme Court also took that and saw, well, maybe there is a right to privacy and so on and so forth. So if we are debating what it is that founding fathers meant, whether they meant it to be a living document or not, I don't think we are going to get anywhere, right? The real question is whether we can use this Constitution for contemporary issues or not.
Let's kill one myth that just came up. We talked about the right to privacy, and you're absolutely correct. The right to privacy, I think, first came up in Griswold versus Connecticut, a case where Connecticut had an ordinance prohibiting the sale of contraceptives and the use of contraceptives. And the Supreme Court established the right to privacy in the mid-'60s in that case, expanded it in Roe versus Wade to apply to abortion. I just heard the typical right-wing myth that it was a liberal court. There were 7 justices decided that opinion in the majority. 2 dissented. One of the dissenters was a Kennedy appointee. Five of the 7 in the majority were appointed either by Eisenhower or Nixon. Some of them hadn't been on the bench for more than a short period of time. It's a complete reversal to call that a liberal court. Nobody calls Nixon a liberal, and I don't think anybody calls Eisenhower a liberal. That was a conservative, right to privacy decision by what conservative used to mean, what it meant in the 60s and 70s. I don't know what it means now, but back then they meant keep my government, keep your government in your hands, out of my bedroom, off my contraceptives, and out of my relationship between me and my doctor. That was a conservative opinion by justices appointed by conservative presidents. One Kennedy appointee was in the dissent, and one was in the majority, as I recall. I can't remember where the 9th justice who appointed. I think it was Douglas, appointed by FDR, if I'm not mistaken. I think he might have still been on.
Thank you. And privacy actually brings up a great point, and specifically in considering rights. I know you have a burning point, Heather. You might have to save it.
Can we clarify something?
Yes.
Are we all in agreement then that the Constitution is a living document?
Yes, I think so.
With the rise
Yes.
of hands.
Okay.
Thank you. So rights is actually privacy is a great segue into a bigger conversation about rights. Specifically, were there any rights that states had considered important before and during the development of the Constitution that were not added? And if so, do you feel that any omitted matters would be relevant or address current social issues today?
Let me say that first. The Ninth Amendment of the Constitution reads that the enumeration of certain rights in the Constitution shall not be construed to disparage or deny the others retained by the people. So people have the other rights, but what rights are the other rights? And those rights have existed already before the Constitution is drafted. So it's up to the Supreme Court to interpret. Like Gordon said, I mean, privacy can be one of your other rights, abortion, right to die. I just watched a documentary about Dr. Jack Kevorkian. He was running for the Congress in 2008. Of course, he lost. But his argument is that if he were elected to the Congress, he would publicize, promote the Ninth Amendment. And he wanted to put the right to die as part of the rights to be spelled out, to be specified by the Supreme Court. So other rights, but again, what rights are the other rights?
I just, as I understood the question, it was what rights were there, did the founders believe in before and during the debate of the Constitution that they did not add to the Constitution?
Specifically, it was more along the lines of what states had originally proposed as rights in their own drafts of their own individual constitutions, and those that were not considered. Specifically, do you feel that any of them would be better off in the Constitution today, or should there have been more thought around this when they were developing the Constitution?
Well, they passed Amendment 10. Amendment 10 specifically says the power is not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So other than what was in the Constitution, they basically left to the states. That would include local police regulation, local zoning. Taxation was a huge item. The first federal income tax was passed, was declared to be unconstitutional. So unfortunately, they went and passed a constitutional amendment authorizing it. So I think what the dilemma is in answering this question is that there's been a slow creep over the year, and then actually a deluge during the FDR administration, of the federal government grabbing, one way or the other, more powers away from the state. We joked before we came in here, what are we going to talk today about, the Commerce Clause? Well, now we're going to talk about the Commerce Clause, because it was the Commerce Clause that they largely used to expand their power. We talked about Obamacare. Well, you know, there's kind of another horse that's been out of the barn for about 30 years, because we've had ERISA for 30 years that regulates pension plans, health care plans. There's been all kinds of federal regulation in these kinds of areas. What we have now more recently, though, is that we have an argument about it. Congress passes a bill, and under ERISA, for instance, I don't think there was too much constitutional debate about that. ERISA is it regulates basically any employee benefits type of plans. There was a debate about it, but after it passed, I don't think there was the kind of mass number of attorney generals grandstanding all over the country to file lawsuits against it like Mike Cox is doing at this point, and a lot of other attorney generals across the country.
So again, just to frame our conversation a little bit more, we're speaking about the rights that states had originally considered that were not included in the Constitution in its current form.
You know, when James Madison was left with the responsibility after the first Constitutional Convention of going out and talking to the individual states, or after the second Constitutional Convention, before they were going to ratify, he was left with the responsibility of going out and asking the states, what will it take in order for you to ratify the Constitution? He came back with a list of 20 amendments or changes to the Constitution. They were eventually whittled down, and strangely enough, number 14 in that list looks very, very similar to the 14th Amendment that was actually passed in 1868, awarding citizenship rights to newly freed slaves and due process clause applying to the states, and privileges and immunities and equal protection. So while they may not have, quote unquote, gotten all of their rights, I think that it's fair to assume that the states were somewhat satisfied not only that some of the most important rights were protected, obviously those listed first, freedom of press, freedom of speech, and certainly religion, which was a huge issue and why the separatists broke away from England and left England. But I think, you know, those, we've already talked about the Ninth Amendment being the catch-all. The rights listed shall not be construed to deny or disparage other rights retained by the people. And as well as the 10th Amendment, which was supposed to be the catch-all. So I guess that is, in my opinion, pretty much what the states didn't get. But
I think what we are trying to say is that there are at least two catch-all amendments
yes,
in the Constitution that basically try to address the concerns of the states. And in the 9th and 10th Amendment, the Constitution is saying, well, if you guys are not happy with the rights that we specifically enumerated in the Constitution, here are two catch-all amendments that are basically giving you some kind of political satisfaction towards the states.
Some states had already established official religions, but the Constitution did not get that into the writing, the text of the Constitution. Instead, the Constitution says that you cannot use the religion as a test for public offices. So that's one of the examples.
I'll just add that the first 10 amendments to the U.S. Constitution were specifically not put in the original document, but they were, James Madison accepted the responsibility for writing them in order to get the Constitution adopted. So none of those rights in the Bill of Rights, and some we consider our most fundamental rights, were not in the original document.
but again, that goes back to what the framers had intended with the original document, and that is a document of limited scope. And the theory behind the fact that when they wrote the Constitution and they listed the powers to Congress in Article 1, Section 8, those 17 delegated powers, their intent was that that was an exclusive list. If it doesn't say that they can do it, then they can't do it. So the list by the Federalists was deemed not only unnecessary, but dangerous. Because if you start listing the things that Congress or the President or the court can't do, then it changes the fundamental interpretation of the original 7 articles. So in my opinion, again, what it comes back to is that the framers of the Constitution intended that the Constitution be an absolute document, that if it doesn't say in here that Congress, the President, the court, or under Article 4 in federalism, Article 6 in the Supremacy Clause, if it doesn't say that they can, then it's left to the states. And I think that's why the states were satisfied with the 10th Amendment.
I think that Heather touched on a great point about the 14th Amendment earlier, but before we go on, it's a great segue to our next question. I just want to remind the audience members that if you do have questions that you're preparing, please just raise your hand. Eric will walk around, give you a card so that way you can complete it, and then he can come and collect it after that. We have 2 remaining prepared questions, and at this time I'll ask the next, and after that, then we will have about 15 minutes remaining for open discussion. So the next question I have is, currently there is a great focus and debate on citizenship issues, even as far as repealing the 14th Amendment. Is this likely?
No.
I have more to the question, but thank you.
We agree.
Yeah, I agree. I agree with Heather.
Or, what do you believe will be likely outcomes of these issues? Do you believe that states such as Arizona will continue to develop their own interpretation and enforcement of these matters?
Until the federal government steps in, yeah.
The first paragraph of the 14th Amendment says that all persons born or naturalized in the United States and subject to the jurisdiction thereof are the citizens of the United States and the states wherein they reside. So to me, really it's regardless of where their parents' status. Your children, so long as they're born in here, they got birthright citizenship. Of course, that's very controversial. Some people say, the children, the illegal immigrants' children, they are not subject to the jurisdiction of this country. And also the original intent is to liberate, the former slaves, to give them, citizenship. But again, if you read the wording, all persons, that means regardless. So I think that part should not be changed.
Yeah, I think the debate about repealing the 14th Amendment is just a silly marginal debate that some conservatives are trying to interject into the election season and doesn't really have any meaning. I mean, the theory behind it is that if you are a legal immigrant in the United States, then you have a child, and your child becomes the citizens, and that you automatically become the citizen. That is not true.
No.
This is not the law of the land. In order for the child to be able to petition the government for their parents to become citizens of the United States, the child has to be 21 years old. And I doubt that anybody would deliver a baby and then wait 21 years.
Right.
Whether that child would be so inclined to file a citizenship petition to the U.S. government. So it's just a silly debate that doesn't really have anything to do with the reality of any problems that we are really facing here in the United States.
I agree.
Yeah, I agree.
All right, great. So our last
Go to the
prepared
question.
question is actually, what do you believe, if anything, needs to be changed in our Constitution? And we'll just go from Heather straight down.
Oh, why?
That's a good
You
question.
can take a few seconds to prepare. We have 5 minutes.
Well, I think it's a beautiful document. No, you know, the Constitution. It's workable. It's the longest running Constitution in the world, and a lot of many other countries have patterned their governments after it in one way, shape, or form. And yes, it's hard to change, and no, it's not perfect, but I would be absolutely petrified if there was a constitutional convention called in this day and age, given the media and the divisiveness in Congress and even within the individual states. I can't imagine that a document like this could be drafted or improved upon in the short period of time in which the framers wrote the document. So
I think we are waiting on constitutional decisions on a number of different issues. I think perhaps the most pressing issue that we want to know about is gay marriage on the federal level. Right? Gay marriage is an issue that is confined to the states right now. There is a case in California that is talking about that. Now it's before the Circuit Court of Appeals in the state of California, and it is very likely that that case would push itself towards the Supreme Court. So how this particular issue is going to be solved, whether there will be some kind of constitutional amendment, which is the only way in which we can change the Constitution, right? Whether there will be some kind of constitutional amendment that will address that issue or not, I do not see a necessity for that. I think that could be resolved by the interpretation by the Supreme Court of the current Constitution and by the federal laws. But I don't really see any other necessary looming change of the Constitution, but others may disagree, so we'll see.
Okay. I really think that a new amendment should be added, and that's the amendment of I should say that's the Bill of Responsibilities. I mean, it's not, it's the Bill of Rights. I mean, everybody knows this. You got all of these. I think I'm very in favor of the introduction of the universal national service. If the bill passed in the Congress, I think that would be good. That would be a good idea. I mean, also good to everybody. It's the universal national service requires every able-bodied American to, usually from 18 to 42, to devote 2 years out of their lives to, national service. Maybe you can join the army, maybe you can do some civilian project, but you need to leave 2 years out in your life to do something for the country. I think that's very fair and reasonable. I mean, living in this great country, I mean, a great democracy like the United States, living, enjoying the benefits, I mean, you have to do something in exchange for what you receive. Freedom is not free. Even though, freedom is priceless, yes, but, you need to do something in return for what you receive. So in that regard, I think, universal national service should be recommended, should be introduced to the Congress. Yes, it's being defeated 3 times, maybe 4 times already. But I think that's a good idea. So that's my thought on that.
Well, there's quite a bit, actually, I would think about changing, but the first thing I'd put in is an equal rights amendment for women. I'd put in civil rights protections for against discrimination along sexual orientation lines. That's just to name a few. The right to die, I'd put that in there.
I would agree that I'd like to see an equal rights amendment, and I'd like to see the right to die and those things, but I'm as petrified as Heather is of the possibility of opening up that Pandora's box. Look at Prohibition. What a disaster that was. The so-called Volstead Act, they amended the United States Constitution to prohibit the sale of alcohol. God knows what they'd prohibit now if they got their chance to prohibit something and vote on it with a change of the Constitution. There's just too much opportunity for mischief. And you all should be aware that there's a movement afoot right now, in large part, I think sponsored by the former Mayor Logie here, to open up a Michigan Constitutional Convention. And I'm convinced it's just so those guys can do a little mischief there too and get things done. And that ought to be smacked down hard so that they don't get the opportunity to do the mischief, whatever they have in mind. But they're not doing it just for their health.
Okay, thank you. I'm going to begin at this point by introducing you to the audience questions. And the first question that we have is healthcare then a right that should be provided to all people or a privilege to be earned morally? Oh, excuse me, monetarily. Thank you. So we know where that question came from. Do you need to repeat
I
the
think it
question?
should be a right. Yeah, absolutely. I think everybody has a right. I should have a right. They don't now, but everybody should have a right to basic health care.
Well, you have a right, but is the government obligated to
Or
provide?
excuse me, yeah, I think the government is obligated to provide. I think everybody should have access to it, which they do not now. Right now, it's a privilege.
Hard, huh?
Oh, well, I'm from Europe, so.
The land of socialized medicine.
Great answer.
So this debate doesn't exist over there.
Well, yeah, it
But-
sounds. I'm so sorry.
Yeah, I do not think that. I was reading Constitution just the other day for 536th time, and thinking whether there is any kind of, whether there is a part of the Constitution which, by a stretch of my imagination, I can interpret as offering healthcare as a civil right, because that's what you're asking, civil right, the right given to you by the government. And I couldn't find that. There is such a civil right in the European Charter of Human Rights, right? There is such a right over there. But I do not think that there is anything in the Constitution that would guarantee healthcare as a civil right. Yeah. I mean, Ninth Amendment is tricky, right? Because it is asking us to decide what it is that our rights are, right? So how do we determine what the human right is, right? Do we have some kind of a social contract, some kind of a tacit agreement among ourselves that we should do that? I think that this is the way in which the rights are decided, but I do not think that the prevalent political culture of American society, I may as well be wrong, right, perceives that healthcare is something that should be provided as a civil right. Perhaps, yes, people think it's a human right, but I don't think that they want to go to such a stretch that would include that human right into the catch-all Ninth Amendment, which would basically provide it as a civil right.
Okay.
Yeah.
I think Americans are very accustomed to the idea of the rights as legal rights, equal rights to vote, that kind of thing. If you stretch the rights to cover economic conditions, material conditions, that would be very hard for the Americans to agree. There are two ways to understand your rights: political rights, legal rights. That's one, but social rights, economic rights. including healthcare. But this part is very much accepted in Europe, in Canada, some other countries, but in the United States, we just confine ourselves in just legal rights. That's our rights, and that's also our equality.
And that's not the type of government that we have.
Okay.
We don't, I mean, we have a government that was originally created by the framers to give rights to the individual states to take care of the health, welfare, safety, and morals of the people. So originally, it was intended that the states be the ones to take care of their people because the states are much closer to the people, and the people have way more control of what goes on in the individual states than they do at the federal level. And to guarantee or to provide health care for everyone in the United States, we all, I think, can look back in history and see when the federal government has tried to make a blanket approach to just about anything. One size does not fit all. And that's why we do have the federal system the way that it is, that the individual states are better able to take care of their own people. And included in that.
There is one group that has an absolute right under the Constitution to health care, and that's prisoners across the country, under a different section of the Constitution. But I think, in answer to your question, I think the constitutional concerns, at least in my opinion, with regard to universal health care, went away with Social Security. I mean, we've had that since the 1930s. There's not a conceptual difference between providing a uniform pension plan, for lack of a better term, than there is providing universal health care. I don't think it's a constitutional argument, quite frankly, one way or another. Once you get past the limitation, once you get past that the government has the right to do it under, I assume it's the Commerce Clause again, it's a matter for the legislature. It's another area where it would scare me to death, I think, to start messing with the Constitution over that.
Okay, thank you. The next question is, how do you think the Constitution could and or should change in relevance to the digital age? And how could it apply to things like net neutrality, freedom of speech, censorship, patenting of ideas, etc.? I do understand etc. is a loaded term, but with what's included.
I think it's very difficult for the Supreme Court government to keep up with the technology. I don't even know how you play your iPhone or iPod. They're so alien to me. So I think the legal question, the legal challenge is that pornography should be involving real person, real injury. But today's pornography is like digital. No real person is involved. So how can you sue? So how can you make a case to the Supreme Court? If there's no real case, Supreme Court just cannot make any rule. So that poses a very real challenge to the Supreme Court in that regard.
Yeah.
Especially if you're an originalist and you're only going to go by the way the framers saw it, you can't possibly address anything new like the internet.
Yeah, if you're asking about the freedom of speech, obviously freedom of speech is enshrined in Amendment number 1. And if you read clearly Amendment number 1, it says Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof or abridge the freedom of speech, right? So it's not really giving you freedom to say whatever you like, right? What the amendment is saying that the government shall make no law, right? So it constrains the government, right? It's not telling you you can say whatever you like anytime against anybody. It's not saying that. It's constraining the government to punish you, right? From punishing you, basically, if you speak against the government. Right? So freedom of speech on internet and the digital age must be regulated by laws. I don't think it can be regulated by the Constitution, right? Because that's not what the amendment says. It says government will make no law that will abridge that, right? So if the government makes no law to abridge your freedom of speech, right, then basically that's not something that is regulated by the Constitution. So it has to be regulated by law. To what degree is government going to give you the freedom of speech. Right now, the Supreme Court is basically telling you that, yes, freedom of speech is not absolute, right? As long as you call for immediate violence against individuals or groups of people, your freedom of speech stops. And how that can be controlled in the cyberspace, or how that can be sanctioned in the cyberspace, it's obviously the role of the law enforcement institutions to do that.
Well, freedom of speech applies in the digital age, it's one of those examples, goes back to the question about, is the document a living, breathing document? Obviously, the framers didn't anticipate the internet. So how does the First Amendment apply to the internet? It's a question that we're still developing and working on now. And it's a question that the Supreme Court's ultimately going to have to decide as issues come up. Now, with regard to the First Amendment, it's been interpreted more broadly than just the amendment states with regard to freedom of speech. But you're correct. There's a limitation on government and government action, as are most of the Bill of Rights. They frequently don't apply to, for instance, employers in a private situation. We had a discussion about that last night with regard to a gag order that an employer issues. If General Motors issues a gag order, you're out the door, you're gone. If the city of Grand Rapids issues a gag order, it implies, because it's the government acting, even against its own employees, it implies other issues with regard to freedom that private employers aren't necessarily held to. They are held to them with regard to discrimination based on race, those type of issues. But I unfortunately tell people when they come to see me that have freedom of speech issues with regard to an employer and they got fired, I said, you got a union contract? No. I said, well, then you're gone, because there is no right to freedom of speech with regard to a private employer.
Okay, we have one final question. This one is actually prepared for Professor Bai, but after he follows up, anyone, if you have any additional follow-up, please chime in. So, regarding national service, on what authority does a government derive the power to force someone to labor for the state? Isn't voluntary labor, i.e. military work, a service to society?
It's based on social contract, the concept of social contract. In leaving any society to exchange for protection from the government, you have to give up some of your rights. And that's the idea from John Locke. As far as what kind of services, military, civilian, anything. Volunteerism, to me, is not enough. It's way from being sufficient. Everybody should be required to do something. And that can also promote equality. I mean, for the war, I mean, most of the soldiers are from the low-income families. Now, what about, the people who enjoy, luxury life, living, above a certain level? I mean, do they send their children to fight? So national service can also make us equal in that regard.
Would anybody else like to also respond to that?
I don't know. I'm from a collectivist society, right? So I find the idea of giving back to society very appealing, right? But I'm not sure that it will fit American political culture of, I think, very strong individualism, right? In which individuals say, well, the government does not really have the right to force me to do anything, right? Or it has very limited powers to force me to do anything, right? But yes, I mean, Locke's, as Yun said very well, Lockean conception of the social contract says, well, you cannot be too greedy, right, in asking for your rights. You have to give up part of your personal benefit for the welfare of the whole society. I mean, there is this famous notion of Lockean proviso. He says, well, you can have only as much land as you're able to work on, right? And in that process, you have to leave enough and of the same quality to others. But then, the longer he writes Second Treatise of Government, the more disappointed he becomes about that, right? He understands that, yes, people acquire more land than they're able to work on. There will be issues of redistribution, right, and scarcity of resources, and therefore the government needs to jump in, right? So, while I find it theoretically appealing, and I think many European societies do have some kind of idea and culture of social contract, of giving up part of your personal rights, benefits, and freedoms for the benefit of the whole society, I do not see how it would fit very well American political culture.
Let me ask you, how many of you know the words by JFK in 1961, January the 20th, in his inaugural speech? Ask not what the country can do for you, ask what you can do for the country. So I think this country lacks, what it lacks is collective sacrifice. We're in the same boat. To make this country greater and greater, we need to do something really. You know, it's not just our right. We're talking about, I think we have talked enough about our rights, but what about our responsibilities? There should be a bill of responsibility. I mean, you carry around, you know, in your bag, I mean, you know, right? Everything is right, but again, you have duty.
Well, I lived through a period of where we had compelled government service from about the late 60s to the mid 70s. It was called the draft. And I got to tell you, you want to see something that tears a country apart because of the way they did it, because of who got to go, who didn't get to go. We've had a big debate about that the last few presidential elections. It's a very, very difficult concept that I just don't think the country is ready for. If they had a universal, no exceptions draft with 2 years of service or something like that, I think Israel might have something along those lines. It might work, but it is a bit offensive to our whole concept of freedom that you're compelled to do something like that. I know it was offensive to a lot of people back in the late 60s and the early 70s, and there was hell to pay for it, and that's why you didn't see a draft in the 2000s during the Iraq and Afghanistan situation, because nobody wanted to open up that Pandora's box.
Maybe we can be compelled to quarter soldiers in our homes instead.
Yeah, some people say that's very dangerous. Yeah, I know that. Yeah, people don't want to be surprised by the government. Yes.
Okay, and at this point, I'm just going to take a few moments. If at any point I cut you off during a key point or any last words that you have to share about the Constitution and some of the things we touched on, feel free to do so at this time, and we can actually start with Pete.
Just last words to share? I had never heard of Constitution Day, to tell you the truth, until I got this. It's a great idea. We have the 4th of July, which celebrates more the Declaration of Independence, but this document, and I'm assuming we'll get into this in a little bit with regard to the ACLU and the House Party Handbook, this document is so important, especially the Bill of Rights, in your everyday lives that you can't believe. This is where you get the right to a jury trial. This is where you get to be free in your home from unreasonable searches and seizures. This is where you get your freedom of assembly, your freedom of speech. I don't know why we're not celebrating this much more enthusiastically every year than we're celebrating. The Declaration of Independence is a good document, but all that did was start a war. This is what we fought it for. We fought it to have this Constitution, and we've fought a lot of wars since then to preserve the Constitution. And I would think that there ought to be more efforts to honor it the way it is being honored today.
Yeah, I too think the Constitution doesn't get enough credit and respect. Although I don't want to make it a sacred text beyond change, but nevertheless, people get all bent out of shape about people burning the flag, and the flag represents the state, but you don't see people burning the Constitution because I think there's an agreement that the Constitution protects us as individuals. It's far more important than the flag. And sometimes the flag seems to be stepping on the Constitution. The state seems to be stepping on the Constitution. And I think a day like this calls people to remember what the Constitution is about and to hold our government accountable, to hold the state accountable.
Before I came to the United States, I got no idea about the U.S. Constitution. I didn't know anything about U.S. government. So when I got here, I went to school. I studied hard. Oh, by the way, if you want to know my record of absence, 0 for all of those years. That's very true. Anyway, I think the Constitution can be improved in terms of the Supreme Court's functions. As you know, the Supreme Court interprets the law, but Supreme Court interprets the law. For Supreme Court to interpret the law, I mean, the case has to be made. So the interpretation has to come after the fact. In that case, some harm has been done already. I mean, if you use the 14th Amendment as an example, in order for the Supreme Court to hear the case, I mean, Congress has to pass a law, and then somebody has to challenge the law, and then, the Supreme Court will hear the challenge. So I'm thinking, to make the Supreme Court to be more proactive, maybe, if we say, to extend its function of the Supreme Court, I think Supreme Court can learn from the model of European model, which is that the judges of the court can hear the cases before they happen or take place. That's not real court, cases, hypothetical. But Supreme Court gave the government, institution, even individuals, the advices. So I think that's something which can, again, prevent, further, which can prevent, the real harm, which can be done to the people in reality.
Right. I would like Article 2 of the Constitution to be changed, which says that only natural-born citizens of the United States can run for president, so that Yun Bai and Arnold Schwarzenegger can run in a three-way race.
Forget about Jennifer.
Who?
Jennifer.
Oh, Jennifer Granholm too. Yes, she's a Canadian. She's Canadian, so. But I would urge you all to read the Constitution. It's less than 4,500 words. It's one of the shortest constitutions in the developed world. And those of you who have Droid phones and iPhones can find an app called Constitution. So you can read it on your phones, and it's really cool.
So the question was, again,
Last words.
Last words, anything you may have been cut off on?
Yeah,
Or
I don't think I can go back to that, and yeah. So, yeah, we're not going to revisit right to privacy, are we?
You may. This is your last words.
and
If
the
you don't say
last
anything after
the
that,
last
that's fine.
words on the discussion.
Yeah, it's your chance, dude.
Well, yeah, revisiting where I didn't get a chance to defend the comment of being the right-wing arguing individual here. When the court made the decision in 1965 to award the right to privacy to individuals, they did so by interpreting it from several different amendments in the Constitution, including the First, Third, Fourth, Fifth, Ninth Amendments. And individual justices made decisions based on where they believe those rights were retained. Some of them included just specific clauses, like in the Fourth Amendment, the right to be free from illegal search and seizure. And I did make the comment that that was a decision made by the liberal court, and it was countered that the justices were appointed by conservative presidents. But while Eisenhower had appointed Warren as Chief Justice of the United States Supreme Court after the unexpected death of Vincent, he did so with the assumption that Warren would make very conservative decisions. And Warren turned out to be the most liberal activist justice on the Supreme Court in a very, very long time, and throughout the 1960s advanced a very liberal agenda. And Eisenhower was actually asked, you know, what were your regrets as president? And he said, I have two, and they're both on the United States Supreme Court. So I think it's clear that presidents appointing to the bench can't always predict what they're going to get with the justices, because oftentimes the longer they sit on the court, the more they moderate their opinions, and sometimes they even switch sides from what was expected of them. And you do see that happening. And you know, I think to argue that the courts, the Warren era was not a liberal activist court, I think is just incredibly misleading. So, I'm sorry, I had to.
That's why I included that. So no, I knew that was a sensitive one. So, all right. So at this point, we're going to take a 5-minute break. But before we go, just as a few reminders, there is going to be a second session that will be led by the Student Congress parliamentarian Chaz Rodriguez, and he will be helping assist Pete Walsh, who is here again with the ACLU. I'm talking about personal individual rights, and specifically they'll be presenting the House Party Handbook. And I would also like to, at this point, to invite you to join in with refreshments. We're probably going to break for about roughly 5 minutes, so try to return back here at 4:15. I know it's short, but we are running behind. And before we leave, I would like to say thank you so much to the students who attended, to those who provided questions, to the CFI, the Center for Inquiry, that is, the Student Congress Executive Board, who worked hard to make this happen, Eric Mullen, the Director of Student Life, the Political Science Department, and most importantly, our panelists who volunteered today. Thank you so much for your time.
Can I get a plug in?
Yeah. Say again?
The Political Science Department at GRCC is hosting the 42nd Annual Michigan Conference of Political Scientists on October 21st and 22nd.
It's Social Sciences Department.
This is its own department. It deserves it. And Lieutenant Governor John Cherry is going to be our keynote speaker on Thursday, and political analyst Bill Ballinger, our keynote speaker on Friday. So you can register for that conference at the homepage of GRCC. So I invite you to look at it. Thanks.